I have read the motion by Ms. Wagoner, and I want to deal with that one because there's some things in there that are also troubling to me. But Ms. Schmucker, did you receive a copy of that motion?
Yes, I did.
Okay, thank you. Ms. Wagoner, anything you want to add to that motion before I hear from Ms. Schmucker on that one?
No, Your Honor. Well, I would focus on one added, I guess, request and issue of importance is that Ms. Schmucker has changed the children's school. My client has re-enrolled them in their original school. He did not consent or agree to their change of school. And so I would ask the court address that issue to ensure that the children attend the school that they were previously enrolled in.
Yeah, when parties have joint legal custody, which the parties do in this case, by their judgment dated 11/9/20, case law is pretty clear that before you can change the schools of a child, both parties must agree to it. If they don't, then the party requesting the change of school would have to file a motion to change that school. And then this court, by case law, Lombardo, would have to schedule what we call a Lombardo hearing or a change of school hearing before I could ever do that. And then we would have to decide who breaks the tie between you two. And until that occurs, children have to remain in the school district they were at before, unless it's impossible. Sometimes it is. I mean, you get two people that move out of state and the child's school is East Grand Rapids. Well, that can't happen. But so yeah, that has to be in that order. But there were some things going on because it looks like, although the schools were changed unilaterally, they were also changed back, I believe. There's this issue of head lice, which is always a perplexing issue because it really has nothing to do with cleanliness or anything like that. A lot of times you can catch it right from just a bunch of people. The dental neglect is concerning. Children left alone for long periods is concerning. The denial of parenting time and the children's, in my view, inappropriate involvement in this case is something that I can't have that going on. So
am I able to comment on that?
Yeah, go ahead.
Well, I'll comment on a few. So about the school changes, Mr. Verikan has never, like, he knew we were moving out of the district. He also doesn't live in the district of the school they were going to. It was never malicious on my part to change the schooling. We moved districts, so I enrolled them in a new district. Never in the history of the children has he argued with me about changing the school. It's always just made sense. You move to a new district, the children move to the new district. So that was the only reason that they were enrolled in the new school, was because we moved out of district. And neither Mr. Verikan or I live in the old district now. So, okay. I mean, now I live in a new district. They're 2 miles away from their new schools. And so I apologize. I didn't mean to do that maliciously.
No, I mean, I don't know, you know, I on Friday mornings, I can't delve into someone's heart. I don't know where they're coming from. I'm just here to quote you the law. So I don't have any reason to doubt what you just told me, Ms. Schmucker. But my job is to enforce court orders, and the children have to go back until the parties agree. And if they can't, then I have to have a motion on that specifically. Okay.
Yes. Well, then I would ask how the children are supposed to get to and from school if neither of us live in the district.
That is a perfect question for a motion that you would have to file. Okay.
Okay.
I can't answer that today because that issue is, quite frankly, not in front of me.
Correct. Well, with school starting Wednesday, then I don't.
Yeah, the parties have put themselves in a real pickle, haven't they? It's always difficult when parties agree and parties have legal custody, because these things are made, like yours was made 5 years ago. Apparently, a lot has changed since then. So maybe we need to take a fresh look at that as well, because if the disagreements are too severe, then we're going to have to consider giving one of you legal custody and kind of icing the other one out. And I hate doing that, but I have to keep the best interests of the children in mind. Okay.
Of course.
So what I'm going to do, based on what I've read, I can't change custody on a Friday morning. And obviously, pursuant to Sabatine versus Sabatine, all the requested parenting time changes would affect an ECE. So I have to use the more stringent test of Varka. I think some of the things, and obviously these are only allegations at this point, and Ms. Schmucker will have every right at the front of the court to contest those. But I do believe proper cause or change of circumstances has been shown on Ms. Wagoner's motion to take another look at the custody issue. So I am going to order that both physical and legal custody, parenting time, and child support be sent to the front of the court for an investigation and recommendation. They can do a deeper dive into this, and then they can make a recommendation to me. Ms. Schmucker, are you currently working?
Yes.
Okay, so the fee for that is $300, $150 a piece. So I'll order the fees to be split on that. And obviously, in the meantime, the order that's in effect must be abided by, to and including the school. And I would like another provision, Ms. Wagoner, in an order, because I'll do the order of reference. I want a provision that the children are not to be made privy to any of this court involvement. If I have the need to talk to them, if it gets to that stage, I will. And recent case law said that's pretty limited to just a reasonable preference. So we'll have the front of the court do a deeper dive on all of this, and they'll make a recommendation at some point. Ms. Wagoner, anything else I need to know?
No, Your Honor, I will prepare the order.
Thank you. Ms. Schmucker, anything else I need to know?
So as of right now, everything is just staying as is.
Yeah, I can't change anything on a Friday morning.
No,
Okay.
understandable. Yeah.
I wish you all the best of luck coming up. It's a lot easier to come to agreements than they last a lot longer than having me pop in, but I'll leave that to both of you. Thank you. We're adjourned.
Thank you.
Thank you.
All right, let's move to number
All right, turn this on.
10. And that is case number 1509013 DP Palmer versus Shannon. Jamario and Tiffany, if you can unmute and turn your cameras on.
Okay, my speaker is on. I'm trying to see.
It is on, Mr. Shannon. You're broadcasting to God and everybody. Hey, I can hear everything you're saying to me.
Okay.
So good morning.
Good morning, sir.
It works a little bit better if you find a place to land, because otherwise it will cut your microphone out time and time again. And we want to hear everything you got to say. So this is your motion, and joining us also is Tiffany Palmer, Ms. Palmer, good morning to you.
Good morning.
I have read Mr. Shannon's motion. Have you had a chance to look at that, Ms. Palmer?
Yes, sir.
Okay, I've read it. So is there anything you want to add to it? I've also had a chance to do a little deeper dive in the file as well. But anything else you want to tell me about this, Mr. Shannon?
No, there isn't. We've actually come to a very, very common ground, and we're switching right now. He's gonna take the kids, and I'll have them on breaks.
Is that correct, Mr. Shannon?
Yes, sir. They are currently in my custody. They're currently signed up in school and everything. Everything's set to go.
You know, I would love if you both could attend all of my motions and show everybody around here how this works, because it is fantastic when two parents, although not together, they can get things figured out. So here's what I need one or both of you to do. I need, usually it's, since it's your motion, Mr. Shannon, I need you to go to the Legal Assistance Center, and I need you to prepare what's called a proposed order and stipulation. It's a document that puts all the agreements that you and Ms. Palmer have put together. And then that's sent to me. Both of you need to sign it. And then if it looks good to me, which normally it does when two parents agree, I will sign on to that. And that will be the new order of the court. Okay?
Yes, sir.
Perfect.
All right, you both are all set with me. I wish you both the best of luck. And once again, you have absolute high praise of this court for doing this. And thank you both very much.
Well, you have a wonderful weekend, sir, and thank you very much for your time.
Too. Thank you. So let me, I've read your motion and I've read your response, Mr. Hodges. And I want to cover, the first one will be the change of domicile. You, Ms. Russo, do not have to file a change of domicile.
Okay.
The last custody and parenting time order was an order that was just recently arrived at. I think it was in June of this year, right? June 18th.
Yes, sir.
According to that order, the parties share legal custody, and the defendant father has a 3-phase parenting time schedule. The problem is this. Changes of domicile are usually reserved for moves out of state and not for these types of things. But even if they were, the parties live approximately, by my calculations, 87 miles apart. And you only need the court's approval if it's 100 miles or more. And it's actually based on the mileage of as the crow flies, right? It's not based on following highways. It's how a crow would get there, straight shot. And a crow would only travel 66 miles. So you would not need to have an order approving a move to Saginaw. Okay. And then also the final basis of that is that at the time you made the move, which was approximately 2 years ago from what I've read in the report or read in your motion and what I've read in Mr. Hodges' response, is that at that time you had sole legal and physical custody. And at that point you didn't need it. So I'm denying your motion to change domicile because you don't need it.
Okay.
Does that make sense, Mr. Hodges?
Yes, sir.
All right, now let's talk about the transfer. The plaintiff, Ms. Russo, lives in Saginaw County, and the defendant resides in Ionia County. I received an order or proposed order that I believe Megan Lipford from the staff attorney from the front of the court had some involvement with, because the arrearages are already listed in there. So I think by last account, there was an arrearage of close to 15,000. Is that correct, Ms. Russo?
Yes, sir.
Okay. And does the child or children go to school in Saginaw?
Yes, sir. And they have for the last 2 years.
All their friends are in Saginaw?
Yes, sir.
They attend extracurricular activities in Saginaw?
Yes. Yes, sir. My daughter is, both of them are involved in the Big Brother, Big Sister program here. Our older daughter participates in sports, volleyball, and our younger daughter has expressed interest in doing Girl Scouts here. So,
So
the only reason
why, well, let me just ask you, let
okay,
me
go
just
ahead,
ask you
sorry.
this. Why do you believe it's in your child or children's best interest to transfer to Saginaw?
So the reason for that is, and the reason I'm asking the court for this is every time I need to do anything with the court or file a motion, I live 2 hours away. So it costs me $60+ in gas, my time, and parking, all that. It would just be more convenient if I needed to do anything with the court as far as enforcement, as far as motions, as far as any kind of assistance I may need with the court. I don't have to travel 2 hours. And that's in the best interest of the child so that I'm not hemorrhaging money to take a trip to file a paper. And prime example of that, sir, is the motion for the legal custody and parenting time visitation, whatever. That was sent to us by email. The problem is that email is encrypted, so the file is only good for so long. It was downloaded to a different device and I had to obtain a new phone. I was no longer able to access that information because the secure link had expired. That left me no other choice, sir, but to drive to Grand Rapids yesterday, which cost me $60 in gas to file or to obtain this motion because it is required by the kids at school. They needed a legal copy signed by the judge they have to have it on their school record so that I'm in compliance with the 50-50 legal.
Thank you. Mr. Hodges, you mentioned in your response, and I read it, so thank you for that her request is really nothing to do with the children, but just because it's more convenient for her. Is that about right?
Yes, sir. She openly admitted to me on Family Wizard that it's for her convenience and not for the well-being of the children.
Okay. But you have to kind of work through the analysis with that a little bit. Is right now you have a pretty sizable arrearage with the front of the court. And what that tells me is that there was a time, or there may still be a time, when Ms. Russo is having to do the lion's share of all of the financial stuff. Not all of it, but not all of it, but a lot of it. That's obviously evidenced by 15,000 in arrears.
Can I explain why I am that far behind?
I get you, but let me get it out first, okay?
Okay, sir.
So when someone is behind in their child support, to force somebody to make the drive here is just taking money away, not just from the plaintiff, but from the children as well. And additionally, if this matter ever went to court on such things as enforcing your arrears, parenting time violations, child support violations, custody matters, all that. All the witnesses, for the most part, would be in Saginaw. They would be teachers up there, their extracurricular activities, friends, that type of thing. So it sounds like to me it's a little bit more than just helping her out by doing this, but you can tell me what you will.
Okay, I'm gonna back this up. I believe that you were the last person that we talked to, um, um, when this all started. This case has started. You
Perhaps I don't.
you specifically, I do, but you specifically told Margaret, why did you move 100 miles away? Because the address starts from the courthouse to her house. So again, she did move 100 miles away.
No, actually, if I said that, I was wrong. It's from the parties' legal residences of one another. And that would be from your residence to her residence, and your residence in Ionia County and hers in Saginaw County are 87 miles apart.
Okay, but this matter, Margaret Russo moved them kids up to Saginaw and cut off all communication with me for 2 years. I have to fight for my children, and my why I'm behind on child support, because my younger daughter, the court caught up 2 years ago, and all that money came about. That's
Right.
why a lot of it is. So what I mean, yeah, I'm behind because the court just gave me that 2 years ago. Just listed me on there 2 years ago. So yeah, now I am behind on, yeah, but I make a $937 payment every month. So I'm in the same boat with her. When my kids come here, I spend hundreds of dollars when they're here. Okay. So,
Okay.
and I got to pay her child support on top of it. Okay. Now, if she moves up there, I'm the one who's been fighting for my children. I'm the one who has to put motions in all the time. I'm the one who has to fight. When it gets moved up there, I'm in the same boat. So there's no difference here.
Sure there is.
There is none.
Okay, I'm not going to argue with you, but I'm going to grant her motion. I'm going to grant her motion to transfer this case to Saginaw. And the motion you filed, I think you filed one for 2 weeks from now, will be canceled, and you can refile that once Saginaw gets all this transfer stuff together. I just think it's in the best interest of these children all around to have the matter in Saginaw. So I'm going to sign your order, Ms. Russo, and we're adjourned. Thank you.
Thank you. Have a good day.
All right. First on my screen is Janelle Willis. Ms. Willis, good morning.
Good morning.
Next on my screen is the defendant in this matter, Stephen Willis. Mr. Willis, good morning.
Good morning.
So I read your motion, Ms. Willis. Thank you for that. And did you get a copy of that as well, Mr. Willis?
Yes, I did.
Okay. I read it. So obviously anything you want to add to it, Ms. Willis, that I don't already know, I'll give you the floor and then we'll hear from Mr. Willis.
No, nothing to add.
Thank you. Mr. Willis, your response, please.
I'm not really sure where to start. I know what the biggest issue is.
Okay, you gonna share that with the class, or you gonna keep it to yourself?
I'm sorry, I'm just a little nervous.
Why?
I don't know. It's like a white coat syndrome. I'm sorry.
I'm not a doctor.
I know. I know the biggest issue is the kids don't like it when I drink at home. For sure. Okay. So I mean, I've talked to them about it. And I get it. I understand. And when something like that is a problem, then it just stops. Like it's not going to be an issue anymore.
Okay. is that something Ms. Willis can take to the bank, or is that something she's been told before?
Um,
Hang on, it's rhetorical, but I'll have Mr. Willis answer it first.
Yes, absolutely, 100%. I don't want it to be an issue. You know, I don't want anything bad with my kids. I want them to feel comfortable at my house. They're safe at my house. They're provided for. They're not abused. They're not mistreated. So like, it's turned into an issue, and I absolutely 1000% want it to go away.
Okay, well, Ms. Willis, how do we make that go away?
I don't know if there is a way. I mean, when we were married till now, I don't know him as not drinking. So to just say you're gonna stop, I had the issue in the past. So to just quit is not the easiest thing. But yeah, that is the main thing why the kids don't want to be there. They're nervous with the driving and the drinking and being in the car, and why they did stay here and why they want to live here, and they don't want to stay there. So they've expressed that to me many times, and why we're here today. So,
well, as you might have heard in prior motions, the law does not allow me to just cut off parenting time on a Friday morning. Before you do stuff like that, you have to have what's called an evidentiary hearing. There has to be a lot more to it, but it is obviously well documented. I mean, I will tell you that the move 45 minutes from school, which does impact extracurricular activities and contacts with friends, is the very case that Shade versus Wright, the seminal case in the area of parenting time, involved. It was an extracurricular move away and that type of thing. I think that before I jump into your business, which I'm going to, unfortunately, because I have to figure out a way to do this. I'm not real enthusiastic about, you live in Ottawa County, correct, Ms. Willis?
correct.
And you live, Mr. Willis, in Newaygo County, is that accurate?
Yes.
Yeah, I'm never excited about Kent County residents spending time and resources for two out-of-county people, but the residence is contiguous, so I couldn't transfer it even if I wanted to either to Ottawa or Newaygo. But what I'm going to do is I'm going to find that pursuant to Shade versus Wright, 291 Michigan Appeal 17, a 2010 case, that there has been proper cause or change of circumstance to revisit the issue of parenting time. Obviously, the move by the defendant, and more importantly, the use of alcohol, the requisite best interest factors found at MCL 722.23 are paragraph C, paragraph G is in George, and L. I find that to be relevant too. So what I'm going to do is I'm going to, since I can't do it on a Friday morning, I am going to sign an order of reference to the friend of the court for a complete investigation and recommendation as to what parenting time should be. Are you currently working, Ms. Willis?
Yes.
And Mr. Willis?
Yes.
The fee for that is $300. It will be split between you two. And make sure the friend of the court has all the correct information, because they don't forward mail. I want everybody to participate in this. The last thing I need you to do is this, Ms. Willis. I need you to prepare an order that I will sign that says that the defendant, Mr. Willis, cannot consume alcohol 12 hours prior to or during any parenting time with the children. And you can submit that to me and I will sign it. And if he's serious, and I have no cause to doubt him, because he looked serious to me today, that he's going to, but alcohol is a tough thing. It's a fight every day, believe me. And I hope it turns out the way you want it to, because what the friend of the court may do is, if that gets violated, and that's why I'm starting there, because if that gets violated and there's information that you are doing this in spite of a court order, then there's other means to enforce, such as SoberLink, such as other alcohol testing devices. I'm not going to go there right now. I'm going to take you at your word, Mr. Willis, and just put an order on there for everybody's protection. But you'll be hearing from the friend of the court shortly. Like I said, make sure they have their correct address. Then they'll make a recommendation to me. And once again, the parties will meet with the friend of the court and they can resolve it themselves if they want to. If not, then the friend of the court will do a complete deep dive and talk to whoever you want them to talk to, and they'll review everything you want them to review, and they'll make a recommendation to me. Okay?
Okay.
All right. I wish you both the best. I hope it's a fight, Mr. Willis, and I wish you the best of luck going through that. Okay?
Okay.
Thank you. We're adjourned.
Next is gonna be number 4 on our list. Case number 2300774 Diaz Cunningham versus Cuevas Villegomez. And then Martin, can you turn on your camera and unmute, please? There we go.
All right. First on my screen is the plaintiff, Ashanti Cunningham. Ms. Cunningham, good morning.
Good morning.
Next on my screen is the defendant, Martin Cuevas Villegomez. Mr. Cuevas Villegomez, good morning.
Good morning to you.
So this is your motion, Ms. Cunningham. I've read it. Is there anything you want to add to it before I turn things over to Mr. Cuevas Villegomez for his thoughts?
No, he showed up. Besides me trying to serve him, he ripped the papers up in my face. My main thing is just really just the custody and parenting time. He just feels like because he's been paying his child support these past few months that he doesn't have to do more than pay child support. He picks and chooses when to get the child. That's just the biggest issue.
Okay. Mr. Cuevas Villegomez, your thoughts, please?
I don't pick anything. I was under the impression that she wasn't allowed to serve me, so I will say that I didn't read it. I also was she said something about me picking and choosing when to get Malaya, or my daughter obviously, but I get Malaya every weekend, every Friday, Saturday, and Sunday. I don't understand what this was even filed for. I took a trip a couple weeks ago, and that's really where it kind of picked up at. She got upset because I went out of town for a weekend, and it was my weekend, but I let her know Monday. Friday came around, we got into an argument about it, and then, I had already paid the money and whatnot, so I went out of town for the weekend. She didn't say nothing. 2 weeks went by, and then we had a good we were getting along still. We co-parent good. We don't really argue much. When we do argue, it's because of something that we just can't agree on, obviously. Really, more than anything, it's about the parenting time schedule. I get every weekend. I pick up every weekend. We have a certain schedule that we even got set up already.
Yeah, I know.
It's just more Yeah, it's in the benefit of like, it was based off of a work schedule that I used to have and one that she used to have. So she says that weekends are the only days she has off, which are the only days that I have off as well. I've asked to be included in her academic life.
Yeah, let me
I
stop
have,
you there, Mr. Cuevas Villegomez. You can be included in all that stuff, but the motion I got is a motion for a change of custody. And Miss Cunningham already has full custody, legal
yeah,
and
so
physical custody,
yeah,
unless, hang on, let me get it out first, okay? So you already have what you're asking for. So you don't need an order saying you have legal and physical custody because you already have it. Now it's subject to the defendant's request that this court review what's called legal custody. But that isn't in front of me, and no, it hasn't been filed yet. And I just want to tell both of you things. First of all, courts can do a lot of things. But courts can't make people good parents. Either they are good parents or they're not. And if there's a parenting time order that is not being followed, all right, for whatever reason, then two things got to happen. Either one, the parties got to change it, and the parties themselves can change it, because if you both have, the only time you can have time with the kids is on weekends, you both can't have them, because if you're every weekend, then she gets aced out of it and vice versa. And then, so the most logical thing to do is for you two to sit down and say, okay, it should be every other weekend. Then both of you can split that time. But
right,
these parenting time complaints, if someone is not complying with the parenting time order, either Ms. Cunningham is not allowing the parenting time, or Mr. Cuevas Villegomez is not picking her up when it's supposed to, then you have to file a complaint by statute. MCL 552.644 says you have to file complaints at the front of the court. They then will try and meet with you and figure something out. And if they think it's enough that I got to hold somebody in contempt and possibly put them in jail, they'll bring it to me. But those complaints don't start here, they end here. So they have them right online, Ms. Cunningham and Mr. Cuevas Villegomez. So you can fill those out online and make parenting time complaints. But at this point,
right.
your motion is for full custody. You already have it. So case is closed.
So it's just closed?
No, it's just the motion's denied because I can't give her what she wants because she already has it.
Because she already has it. Yeah. And I guess, do I just I guess so, under the impression that do I just gotta file a motion for a different parenting time? Because I guess that's the issue at this point.
Yeah. That was what you would
It's
have.
like okay.
This motion's for
Okay.
custody.
Okay, so
I didn't file the motion, but I understand.
Okay.
Okay, I filed the motion because I was told that we had joint custody. So, and I
Who
was
told you that? Who told you that?
At the friend of the court, I was told.
How much did you pay for that advice?
I paid $100. I paid for the motion. I paid
No,
$100.
for the advice.
For the advice, none.
Right. And that should be your benchmark from here to forward. If you're going to rely on advice, it better be advice you pay for, and that's from an attorney, okay? Because you don't have joint legal custody. You have
full custody.
Full 100% custody until the defendant brings a motion to me asking that I consider legal custody and physical custody. So, but the Legal Assistance Center might be able to help you out. They're pretty good about these things. But
I say if that's on the flip forward, then that's where I win. But I'll file the right motion. I just feel like overall, there's nothing going to work. It's been 4 years. We started off with you, sir. Martin originally took me to court for parenting time and has not abided by his parenting time
Yeah.
all these years.
And I told you
But
what
if
to
I
do.
have,
Stop
but if
talking.
I'm
Stop
sorry.
talking.
If I just have full
Stop talking.
custody, that
No.
was my biggest thing. So
Okay.
I'm okay
When I
with that.
say stop talking, I want stop talking. Now, as I told you, if he is not complying with your parenting time order, you need to file a complaint for parenting time at the front of the court. Those start there. They end here, but they start there. So that's what, if you have problems with the parenting time, that's where you got to go. And I'll look forward to whatever you guys file in the future. Okay?
Thanks, Brittany.
Okay.
Next is going to be number 3.
Thank you guys. Goodbye.
And that is case number 1604182 DC, Cunningham versus.
I really think we should name this case same time next year, because it just all the time. This has now ballooned to 2 volumes, 5 motions I've heard since 2023, 1 case conference and 1 evidentiary hearing, and a partridge in a pear tree. You're getting a lot of legal oxygen in front of me, and we have to solve this problem. I've read the motion, I've read the response, and my question is this. I'm going to start with you, Ms. Van Dyken. Based on this order, is it your position that if, in fact, that order is violated, that this court doesn't have to do anything except sign an order granting the relief that both of you put in your last order? Or do you think I have to conduct a full-blown evidentiary hearing on all these things? Lombardo, custody, that type of thing.
I think the court signs an order that reverses the parenting time pursuant to the consent agreement. They bargained for, get rid of that evidentiary hearing that we didn't hold to enter that order that said if she dropped below that 90%, it automatically reverses. If we would know that she would go back on that deal, we would have ran that evidence. So yes, the court just needs to sign an order.
Mr. Fricke.
Thank you, Your Honor. She didn't violate the order. To violate the order, the child has to be the child has to be not going to school within compliance of school policy and not going to school on medical advice. Both of those are met. I gave you the whole school policy that was obtained from the school's website. The order hasn't been violated. As to the communication, any violations on that are not to trigger that. Both parties aren't perfect. And I would ask the court if they're going to, if the plaintiff is going to keep his request in place for the change in domicile and change of schools, then yes, it has to be sent for an evidentiary hearing. And it's my position that it has to be set that way anyways.
So you sign on to an order saying that it's an automatic switcheroo if it's violated, and what, you had your fingers crossed behind your back because that's not true?
No, Your Honor, the timing of the filing, he waited almost a month and a half after the school year ended to even file this. School in Florida ends in May. This was filed on July 1st.
I can hear you, Mr. Fricke.
Thank you, Your Honor.
Back a bit, okay? I don't know why people continue to do these things. Why people continue to sign orders that, in essence, waive all of the Lombardo requirements. They waive the custody requirements. They waive the best interest factors. They do all this. And then they come in when they're called on it and say, yeah, you still got to have a hearing. Well, I think you're right, Mr. Fricky. I think I do have to have a hearing on whether first, and I'll take briefs on these things. Number one is whether she violated the order, because according to the, I mean, all I got is the number. And I agree with you, 2%, 3%. I agree with you. One of those absences was Mr. Cunningham's doing. I get all that. But I need an evidentiary hearing as to if she actually violated the order. And I want to see briefs on that. And then the second part of that, I want to receive briefs on whether this court can save parties from their issues and say, well, you know, I know what the order says, but guess what? I can't do that. I want to see that. I want to see what the law says about parties who stipulate to remedies, and then the remedy is that we have to take up a bunch of court time and figure it out. So we'll run like a threshold hearing to see if I have either, because there hasn't been a violation of that order. I'm more concerned with the school attendance. The parties, if they have their own order or have their own issues with these responses and emails and this type of thing, they can file those at the front of the court, 552.644. That's where all the parenting time complaints go. And I consider those parenting time complaints. But I will set up an evidentiary hearing on threshold as to one, whether the order is actually violated. And I'll take a sworn statement from the attendance officer of the school. And two, whether if it has been violated, can this court give the remedy that the parties agreed to, or is that somehow violative of public policy? Because that would have been my response too. If I knew that that was not an effective order, I probably would have said, I'm running a hearing on this way back in 2024. But I want briefs on all this stuff, and we'll contact it's going to be a week. So, because she's gone next week. So if you want to email her about setting up that threshold hearing, and I want briefs, and I'll weigh in on that. And unfortunately, I'm not going to be able to weigh in on it in time for the school year, obviously. So the child stays in school or goes to school as the order provides, and then we'll deal with it. But I will tell the parties this, and I mean this in a very good way. I think both parties are wound a little too tight. Okay, there's a lot of obligations in this order, and once in a while, a couple of times are gonna be late. Either Mr. Cunningham or Ms. Nixon. But that's why, if they are, I want those complaints filed at the front of the court, because then they can try and adjust this thing according to the realities. So contact my clerk and we'll get you some evidentiary hearing dates, and we'll see if we can't put a finalization on this, okay? Best I can do for you.
Thank you, Your Honor.
Thank you.
That is case number 2307460, Diaz Porter versus Kerns.
Here it is. Sorry about that.
No worries.
Ms. Van Dyken joins us again. Ms. Van Dyken, good morning.
Good morning, Aaron.
And Ms. Van Dyken appears, let me just make sure, appears on behalf of the plaintiff, Travis Porter. Mr. Porter, good morning to you.
Good morning.
And the defendant appears, Ms. Kaylee Kerns. Ms. Kerns, good morning to you.
Good morning, sir.
I have read your motion, Ms. Kerns, and I take it you have seen that as well, Ms. Van Dyken?
I have, Your Honor.
Thank you. And you received Ms. Van Dyken's response, Ms. Kerns?
That is correct.
Okay. Anything you want to add to your motion before we hear from Ms. Van Dyken?
Yes, sir. I just want to kind of give you a little bit of since this has all happened until today. Travis is doing exceptionally well since filing this paperwork. He is getting work. He is getting job. He has moved his bedroom out of Olive's room, which was something that we have discussed over and over again. So a lot of these things, he's making strides, which is great improvement. I support that. That's all I want is to support Travis in being a better father for our child. We have not had anything established with the courts yet. So this is kind of step one to get something written to, with these conditions and everything that has transpired. We have been pretty much verbal and we co-parent very well for the sake of our child. We don't have issues on many things. However, it was brought to light what was happening when I filed this paperwork. I filed it shortly after I found out what was actually happening at his household. And I am a stable parent. I always have been. Travis leans a lot on his parents, which I know you've read that in my motion. And the concerning factor is I need to make sure that moving forward, Travis is on pace with getting better, getting help, getting a job, becoming stable on his own, not so much his parents' help. I need to co-parent with him and not his parents.
Well, let me ask you this.
Yes.
Because it seems that probably the better approach, in my view, since you now have Mr. Porter being represented by a very able attorney, is to send each other proposals and see if you two can agree on.
That did happen, Your Honor.
Okay. I mean, Ms. Van Dyken, have you and Ms. Kerns communicated at all?
No, Your Honor.
I didn't think so. He has an attorney on the case now, Ms. Kerns.
Yes.
I would like to give Ms. Van Dyken the opportunity to try and work towards a resolution of this before we start getting into long, drawn-out, expensive court matters. Because it sounds like to me, some of the things you've asked for in the motion are reasonable. Some of the things that Ms. Van Dyken has pointed out are reasonable. It would make imminent sense to me, anyway, to adjourn this motion without date and have you and Ms. Van Dyken exchange some possible proposals and see if you two can't come to some agreement on paper in writing so that
Your Honor, I'm so sorry. That did happen. She sent me a DocuSign a few days ago and I did not sign it because we did not communicate at all. She tried to have me sign something for joint everything down the middle. And with his condition, he is not able to make those decisions right now. So
okay,
that
now,
is
hang on, stop talking, please. Now I'm
okay.
confused now. Ms.
Okay.
Van Dyken, have you had conversations with Ms. Kerns?
I've not had conversations, Your Honor. My client had told me that they spoke and they had an agreement. I put that into a stipulated order and sent it to Ms. Kerns. Obviously, she didn't agree with it, and whatever they were communicating wasn't clear. But I understand this court's wanting to adjourn this, but we need something to be followed. This can't be a unilateral decision made by Ms. Kerns.
Well, I mean, obviously, I'm not going to cut off parenting time. I don't have a problem if his parents supervise, at least for the time being. But as you know, I can't make these decisions on a Friday morning. This is going to be sent to the front of the court. And then you're going to be right smack dab in the place you are before. So I'm trying to look for something to short circuit this. And it would have been a little more productive, Ms. Kerns, if you simply would have, and I don't know if you have, maybe you did, if you simply would have written to Ms. Van Dyken and say, okay, I've got this. These are the things I'm okay with. This is something I'm not okay with. And that's what negotiation is, right? I mean, you just can't, negotiation is not someone sends you something, you refuse to sign it, and then everybody goes their separate ways, right?
I tried to negotiate with Mr. Porter, Your Honor. We are trying to do this between us, not him and the attorney. She really is disconnected between a lot of it.
Can't, Ms. Kearns.
There's no negotiating then, so I
Can't.
guess we have to send it to the front of the court.
Okay, then that's where it's going to go, and the fee for that's $300, and you're responsible for that, Ms. Kearns. And that's what I'll do, because clearly the judgment of support was entered, and what I take it, Ms. Van Dyken, since this is a Sims versus Berrugi matter, you'd be requesting that this court refer it also on legal custody. Is that accurate?
That is accurate, Your Honor.
Okay. I'll do it. There's a lot better ways to do this than this, but I got to do something. So I will complete the order of reference. And if the parties, I will tell you this, if the parties have verbally agreed to a parenting time schedule, I want that schedule followed until we come back into court, unless that's now an issue.
Your Honor, I'm so sorry.
You're chatty, Kearns. Very chatty. Go ahead.
Me and him are in agreements of parenting time. We are not in agreements of legal custody. That is the only thing that we have not been in agreements of. And I just wanted, I'm not trying to be a chatty Cathy. I'm just trying to make sure you understand where we're at with this.
So the parenting time is fine, Ms. Van Dyken. We just need legal custody taken care of.
And I guess I want to clarify, is the parenting time fine as to what I put in my stipulated order as a 2-2-3 schedule? That's in my stipulated order.
I'd have to review the order more detailed before I put it on record. I'd like more time, but essentially, yes, what we've been doing is what Travis told me. That's what he told you. So that's what we agreed on as far as parenting time, but just the legal part of things, because you cannot make decisions. Okay.
I get it. I get it. So I'm going to ask Ms. Van Dyken to resend via DocuSign the order, but leave out the legal custody, and I will send that to the front of the court, and they can chew on that for and see if that's appropriate. That way, we get something started now, and that way the parties know where they stand, and then we can take care of it that way. But it's a good point. I get it, Ms. Kearns. Legal custody is a big step, but we'll see what the front of the court has to say about that, and come back, and I'll have Ms. Van Dyken prep the order that has everything in it as previously except the legal custody, and I'll do the order of reference on that. Okay?
Thank you, Your Honor. I'll send that over to you.
Thank you. Ms. Kearns, Mr. Porter, I wish you both the best of luck, okay?
Yeah.
Yep.
Thank you.
All right, let's move to number 2.
Yes, now. Okay.
And number 2 is case number 1209696DM, Brooks versus Brooks or Ellsworth.
All right, so let me see if I get this straight. On June 6th of 2025, this court heard the parties, did an order of reference, and the issue of parenting time was sent to the front of the court with the fees split. And apparently it was terminated due to the defendant violating my court order and not paying the requisite fees. Is that what I'm made to understand, Mr. Brooks?
Yes, Your Honor.
Care to explain, Ms. Ellsworth?
Yes, Your Honor. Good morning. I have had multiple conversations with Michael. I really would like to think that we can work together without having to do all of this. We've talked on the phone multiple times. We've had many conversations, which doesn't justify me not going to the court. I just really thought that with the history that we both have, that we could work this out together. We could come up with an agreement, we could have it signed and just go about our day. That didn't happen. So I do like to take into consideration the wishes of my daughter, of our daughter. Given the circumstance, I understand that I did have her move to Arizona. I understand that he's home now and he would like to have visitation with his daughter, which I'm not opposed to at all. I reviewed his appeal and I don't think that what he's asking for is unreasonable. I truly don't. The only issue that I have, Your Honor, is that her school is year-round where she's at in Arizona, and she has funky breaks. It's not like a Michigan school where we have like a chunk of time off for spring break or a chunk of time off for summer break. She has like 9 weeks on, 2 weeks off type thing. So I really just need to be able to coordinate with him, not necessarily that I don't want him to see her, but just that we need to work with her schedule. She's in, in activities. She does, she does track, she does cross country, she does Bible studies, she does all sorts of things that she wants to get a job this next summer because she'll be of age. And she just really had begged her dad to understand that she wanted to be able to be a teenager at the same time as well as see him, but we never came to an agreement on that.
Mr. Brooks?
Yes.
Your thoughts?
My thoughts on this are the back and forth of negotiations is not, we can't see eye to eye when it comes to parenting time, travel expenses. Obviously the child lives in Arizona, so that's a very drastic change of circumstances.
I'm not, that doesn't, you're quoting legal stuff, and I think you're using it out of context, but go ahead.
But it doesn't bother me that she's in Arizona. What bothers me is just being able to establish parenting time.
Yeah, I know. That's what that, and I thought I solved this on June 6th. And here we are on August 15, and we're no further to that reality than when we were before. So I will do this. I'm going to send it back there. And this time, if the fees aren't paid, then there's going to be an order to show cause. And then Judge Gottlieb can decide whether someone should be heftily fined, incarcerated, whatever. I want to put an end to this. And the only way I can do it is if the parties comply with my orders. Okay. So I'm going to do it again. And so you're going to get this thing again. And if it's not paid this time, then there's going to be some serious consequences. Does everybody understand that?
Yes, Your Honor.
It's the only way I can do things. I would love the parties to be able to sit down together. In fact, the friend of the court may very well do that. But it's not happening right now. And I wish it was, because you seem like two very good people to me. And I hope you guys can get it together, but we'll see. If you can't, friend of the court will obviously make a recommendation to me. So I will prepare it again. And if you two want to talk, I encourage it. Most lasting agreements by parties last a lot longer than court imposed things. So take that for what it's worth. Okay.
Can I add something real quick, Your Honor?
You only filed an objection to the recommendation.
Well, I was just, so she has cut off contact with my child, and I don't know what to do about that.
That, first of all, that shouldn't happen, Ms. Ellsworth.
Your Honor, I did not cut off communication anywhere. Nowhere have I ever told Alexa she can't speak to her father. She is upset with her father right now because of what he's doing. She has expressed to him that she does not want to come back to Michigan, despite her, even I telling her that she needs to give her father respect, that it's her dad. But I have not cut off communication with Mike and his daughter.
If he calls, I want you to hand her the phone. Now, what happens at that conversation is between the child and Mr. Brooks. You can also write letters, but you're going to have to keep it together until the front of the court does their magic. That's what I have.
Yeah, he's digging his own hole, Your Honor. So but I did not cut off no communication at all. And he would have to contact Grandma because that's where she's at. I'm in Michigan and she's in Arizona. So he knows my mom has had the same phone number for over 20 years and he can call that number anytime.
I will prepare the order of reference. Call your daughter. See if you can make things right again, Mr. Brooks. We're adjourned.
All right. Thank you, Your Honor.
Thank you.
Jesus.
All right, this is number 5, DeCam versus DeCam, case number 24020960M.
So I need to have you, Mr. DeCam, find a place to land. Can you do that for me?
Yes, sir.
So I read your motion. Ms. DeCam, did you get a copy of that, Mr. DeCam?
Yes.
Okay. So the way it works is this. The front of the court came up with a recommendation based on their information and the information supplied by everybody. And they came out with a recommendation. Nobody objected to it. Nobody. Nor did they schedule a hearing until today. So what's the status, Ms. DeCam?
He has been paying some child support very inconsistently. A few months he's just skipped completely and he's been because he's been sending the money. But I would like to get it filed so that it has to be consistent and so that it's accounted for.
Okay. Mr. DeCam, the court didn't get any objections from you, but what do you want to tell me today?
No, sir, I don't have any recommendation to the motion to pursue it as an order for, consistency and tracking purposes. If there's any disagreement, I would say that, and this might be a separate motion that I need to file, but the lack of parenting time is definitely concerning.
Okay. So yeah, that is concerning to me. And it is a separate motion. I'll adopt this and sign it today. And then I will look for another motion in the future unless the parties can get on the same page with the parenting time. And we'll see where it goes from there. But I'll enter this then today and send you guys on your way. And Mr. DeCam, you can prepare a motion. The Legal Assistance Center on the 5th floor can help you do that. Okay.
Okay.
All right. You're all set with me, both of you. Thank you. We're adjourned.
Thank you.
For 8. This is case number 1709028 DS, Houseman versus Webb.
All right. There. So, first on my screen is a plaintiff, Ms. Houseman. Ms. Houseman, good morning.
Good morning.
Next on my screen is Mr. Webb. Mr. Webb, good morning.
Good morning.
Tell you what I know. The current parenting time order is the judgment of support dated November 16 of 2017, and that's parenting time as agreed by the parties. I heard from the parties on this scarcely over a month ago, July 3rd. It was indicated to me that for the last 9 years that the parties have had week on, week off parenting time. And that according to the motion that I got, it says that plaintiff has cut off all contact. Why?
Can I speak?
You can only answer the why. I don't think Mr. Webb.
It was never a week on, week off. We had a mutual agreement of 4 nights a month, 48 nights a year. That comes out to.
Sounds a lot different than what I'm hearing, Mr. Webb.
It was every other weekend.
It was every other weekend. That's
Yeah, it was.
Long than every other week, right?
I was asking for every other week if we went through with the mediation, but as of right now, it was every other weekend.
All right. So I did the order of reference for parenting time and legal custody. Have you heard from the front of the court yet?
Yes.
Okay. You've heard from them, Mr. Webb?
Not yet.
Do they have your correct information?
Yes.
I would make
September 11th.
So here's my question. What the motion is asking for, which is sort of a horse by a different color, is that Mr. Webb be granted what we call interim parenting time, or parenting time while we wait for the friend of the court to sort this out. And generally speaking, I do alternate weekends. That's what I do on an interim basis. And then the front of the court will either make a recommendation for more, make a recommendation for less. But why was all the contact cut off? That seems odd to me.
Because he was arrested on Sunday, Sunday, August 10th, because CPS found enough evidence to call an officer and arrest him for third-degree child abuse from June 8th incident.
Is that still pending?
He was released yesterday.
Okay, so that's still pending, and he was released on bond, correct?
Yeah.
Yes.
What's the bond, Mr. Webb?
It was 20,000.
Okay.
Cash of surety, so like 2,000 is what it was.
Okay.
But is there any way I can speak, Your Honor?
Well, I got some questions here because when I ask somebody why the parenting time has been cut off, because it's a real significant thing, and usually it takes a significant event to elicit that type of reaction. So you've been charged with child abuse in the 3rd degree, is that true?
That's what they're trying to charge me with, Your Honor.
I think they did charge you with it, didn't they? I mean,
no, I haven't been convicted or anything yet,
no,
Your Honor.
you're misunderstanding. I understand the criminal process pretty well.
Yeah.
They have probable cause to believe that you committed this act, and the Detective Bureau charged or sought charges on that issue, and those charges were granted by the prosecutor, and you were arrested. And I agree with you, you weren't convicted of anything. But the child abuse, which one of those, which child was it?
Your Honor, our probable cause hearing isn't until the 25th.
Okay.
Your Honor, so 2 months ago, I had disciplined my 14-year-old daughter with a different mother. My daughter had lied about what had happened out of anger. Her mother and I are united.
Hang on a second, Mr. Webb.
Yep.
And I'm going to stop you because I don't want you to jeopardize whatever case you got by going through all the facts of the case. I'm just trying to see, number one, what you were charged with. And number two is a lot of times, I don't know if that happened here, but a lot of times while the court issues a bond, they will also have what are called bond conditions. And once in a while, not always, but once in a while, they will put a bond condition that you have no contact with anybody under a certain age. And I'm just wondering if they have done that in your case or not.
Nope, it's just only under my daughter Elizabeth, which, Your Honor, her mom has sought with me to, and the lawyer, that my daughter admitted to lying about.
No, stop.
Okay.
I'm trying to, I know you don't think this is the truth, Mr. Webb,
okay,
but I'm trying to save you from yourself, because the more you chit-chat about this case, this is public record, okay? And I don't want you to do anything that would jeopardize your case or put you into further problems, like possible witness tampering. I don't want any of that for you. So I'm not asking you, I'm asking you these questions based on just bond. I want to know if there's a bond condition that prohibits the contact.
it's only my daughter Liz that I'm prohibited from seeing right now.
Okay. Ms. Houseman, what do you know about this?
My daughter came in June 8th crying because she was there, and she was saying, I'm on Lizzie's side. Mom, this was scary. I don't want to go back there. I don't want to go back there. I have to be the voice for my daughter right now. And that's why I waited for the investigation. They found enough evidence. And now I'm waiting September 11th for FOC. That's what the original plan was. And if they found enough evidence to arrest, what do I look like bringing my daughter to an already frustrated household? That when she was there on that weekend, and she came in crying and scared after his girlfriend dropped her off.
Here's the problem, Mr. Webb, is that it looks like, even though the offense occurred against your other daughter.
Yes.
The fact of the matter is that the daughter you have with Ms. Houseman is a potential witness to that. And putting you with that witness could cause you all sorts of problems. And I don't want to do that.
Your Honor, she's 10 years old. You know, when I was, you know, back in the day, if me and my brother got into a fight, and even though I was mad at my brother, if he got a spanking or got in trouble, I still felt bad for him. I understand my daughter felt bad, you know, with her sister getting a spanking, because she's never seen her sister get a spanking before. So of course she was kind of hurt from it. I get it. But my daughter is still texting me. She made her miss her. I just had my daughter last weekend and we went to Michigan Adventures for her birthday. My oldest daughter called Miss Hausman and my daughter crying because they want JC to come over. JC's been begging me, telling me, Dad, I want to come over, but my mom's stopping me from coming over. She's between her dad and her mom, so she's in a hard spot right now.
When is your Mr. Webb, when is your preliminary hearing?
It's the 25th
of August.
Yes.
All right, I'm going to adjourn this motion, and you can renotice it for my motion day after the 25th. and then you can share with me what happened at that preliminary hearing, because that may play a big role in what I do. So
Okay.
I'll adjourn it without date. You don't have to pay another fee. And let's
Okay,
see,
thank you. I appreciate that.
we'll see what happens on the 25th, okay?
Okay.
All right,
So in the meantime, does that mean, because like this weekend is my daughter's weekend. I've went 2 months.
Stop, please.
Okay.
I thought I was clear. I'm not going to make any decision for interim parenting time until after this prelim. Okay. So after the prelim, you can bring this back and then you'll have a lot more information.
Okay. And like you said, there's no fee after that. Okay.
No, there won't be any fee because
All
you're
right,
just
thank you.
motion. Okay.
Yep.
Get together on after the 25th and you can share with me what the results of the probable cause hearing are. And we'll go from there. And quite frankly, the judge, can also amend your bond. And my biggest concern is I don't want you, my concern is for your daughter. Okay. That's where my concern is. You both are adults here, but she's not. So obviously my concern is with that. But I know both of you have obviously parental rights at this point. But I want to know exactly what's going on in a little bit more detail. So I'm adjourning this till after the probable cause hearing. And I want you to let Ms. Hausman know what happened with that, because a lot of times you also have to address a possibility that if the prosecutor endorses her as a witness, that she may not or they may not wish you to have unsupervised contact with your daughter until that case is over. But I don't know. That's going to be answered by the courts on.
I would be okay with that, Your Honor. But Mrs. Hausman has me blocked. She's failed to communicate with me in all areas. My mom, everyone. So it's
I get it. But right now, we're waiting until after the 25th.
Okay, and that's fine. That's totally fine.
And that's for both of you. Well, it's for the child's protection, but mainly for yours as well, Mr. Webb.
Yep.
I do not want you running into problems with bond or prosecutors or anything like that. So we'll take this back up on my first motion date after the 25th. You can fill me in on all the details, please. Okay.
All righty, for sure.
Good luck to both of you.
All righty, thank you. Have a good day.
Number 9. Case number 23-12628 DM Milleron versus Milleron.
All right. First on my screen, the plaintiff in this matter, Mindy Milleron. Ms. Milleron, good morning.
Good morning, Your Honor.
Next on my screen is the defendant, Mark Milleron. Mr. Milleron, good morning to you. Can you hear me?
Good morning, Your Honor.
Okay, there we go. So
I can hear you just fine. Yes.
Okay, good. So I've read your motion, Ms. Milleron. Did you get a copy of that too, Mr. Milleron?
I did, yes.
Okay. Here's what I know, and then the parties can fill in the blanks for me. The last uniform child support order was dated July 30 of 2024, approximately 1 year ago. The order provided for the sum of $970 for 2 children and $494.50 for 1 child. And what's interesting to me in those guidelines is that most of that appears to be childcare. And in fact, the motion alleges that there's a change in circumstance because the daycare costs increased. Isn't that something that's going to happen every single solitary year? So how in the world are we going to visit this every year, Ms. Milleron? Because then I'm going to start hooking people up for court costs, because this is becoming a situation where I don't know how you or why you would want this in a child support order and not just in an order in the divorce case, right?
Yeah, I can definitely answer that. It will be a continuation until the youngest child, minimal, goes to regular school. He's going to be starting pre-K at the daycare this year because he's not old enough to start kindergarten until next fall. So they're both in full-time daycare and summer. I don't know what next summer will look like. Our daughter is also in before and after school programming. And I guess, I had definitely let their father know that it had increased at the beginning of the year, thinking that we wouldn't have to go to court and that it could just be made up. I don't know any other way to do it other than to file a motion, I guess, because I don't get additional funds unless it's written in a court order.
Yeah, that makes sense. But see, you have it written in a UCSO, in a Uniform Child Support Order. So what that means is that instead of just popping into court and or having the fees gradually go up, this is in a child support order, and every single year you're going to have to do it this way. Did the attorneys representing you on the divorce suggest that's the route you go?
They only presented putting it in the order as it was. I didn't know there was another way to do it.
Okay. All right. Help me out, Mr. Milron.
Yes, sir.
Anything you want to add?
I certainly want to have to do this every year. I mean, the daycare costs are going to continue to fluctuate. As I said in my response, the daycare costs are actually going down here now that school is starting up because the youngest is going to be starting pre-K at the daycare, and the childcare amounts are actually going down for him as well as my daughter. So if we were to grant the requested motion from the mother to increase the child support, I would then have to a month later file another motion to decrease the child support because it went down for the child care. I think there's some confusion in the UCSO what the line items are for.
I knew that was going to happen because it was a unstable connection. We'll give him a second, see if he can.
Sorry, drop for a second there.
Yeah, turn off your camera, will you? If you turn off. There's such a lag because
my camera is off, sir.
I still see you. There you go. Now, can you still hear me?
Yes, I can hear you, sir.
Perfect. So you make a good point. I mean, when are we ever going to have peace and quiet in this case? And we have to keep coming into court because daycare goes up, daycare goes down. Most people don't do it like this. There's other ways to do this. But here's what I'm going to do. I'm going to send this back to the front of the court and they can come up with possibly another way to do this, maybe a 1 or 2 part order or something that's going to avoid you two from having to pop into court all the time.
Yeah, that would be great, to be honest. I just want half a daycare covered. That's really all I want.
Yeah, I mean, and if there's a separate order that just takes it out of this process, because then the parties can, if there's an order that says you're responsible for half the daycare, currently it's this, and in the future, if it goes up or it goes down, the parties will reevaluate, something like that. I mean, maybe that can be done, but I'll send you over to the front of the court. Maybe they can help you with getting this thing taken care of, because I don't want you guys to have to keep spending time and money and all that stuff coming in here. Sound like a plan, Mr. Milron?
Yes, sir, it does. I hope that they'll be able to help us sort this out and understand the amounts.
Yeah, I think they will. They're pretty wise people over there. All right, I'll do the order of reference.
They've been very helpful every time I spoke to them.
Well, I'm glad. We don't always get that from people on the front of the court. So I appreciate that. And we'll see if we can't fix this for you both. Thank you.
Thank you, Your Honor. Appreciate it.
You can sign off.
Thank you.